I was expecting to leave a voicemail. I'm sorry.
No, I asked you to call the office and leave a voicemail, and I will call you back.
I'm sorry. Was this not the office number? I just checked my caller ID.
No, this is not the office number, but that's okay. I got an email from the clerk who said that you had some questions.
Yeah, I had 3 questions I asked her to write down.
She did. So, in answer to your first question, yes, the judge is probably going to recuse himself on hearing any of your matters for the accusations that you made in your declaration of prejudice. And for your second question, I don't know who will be presiding. We'll either get a commissioner or a visiting judge. Whatever I can do for whenever the hearing is, these need to be specially set now, or at least organized with me, since you are asking him to recuse himself. And thirdly, your orders on adequate cause weren't signed because Commissioner Safar said, at least the minutes reflect, that the proper procedure wasn't followed and the court wasn't going to take any action.
Okay, and the proper procedure was, from what I was understanding, and I know I can't quote Bryson, but he said that the judge, I said, was it an adequate cause or the fact that he's not going to recuse himself? I said, I just need clarification, and he said it's due to the recusal. And so could somebody else not have signed that order? Or is there only one judge in Douglas County?
There's only one judge in Douglas County, and I didn't see the order to ask Commissioner Safar to sign it, and this is the drag. When you ask the judge to recuse himself, if it doesn't come to me, I won't know that you have presented anything.
Okay, and then so if he's going to recuse himself...
Being done wrong was not because of the recusal. The reason that he said proper procedure wasn't filed, hang on, I'll read you the minutes. Just 1 second. Okay, there's the motion. Sorry, I'm looking at the file now. And the motion hearing. It was Commissioner Safar. It was on March 17th. The court addressed the respondent, which would have been Mr. Adams, I guess. No, that's you, regarding procedure. The court noted that the order for show cause was not filed and that proof of service was not provided. Attorney Collier did not dispute service, and the respondent addressed the court. Attorney Collier stated that the order had not been signed, so they have not provided a declaration. The court addressed the respondent, which is you, and it doesn't say what the court said, or what you said, but Attorney Collier stated he would accept service from Mr. Duncan. The court takes no action today as proper procedure was not followed. And, all I can do is interpret these notes the same as you, and I would say that it probably means that he accepted service, but the order to show cause was not filed.
Okay, and I filed that on February 18th.
Mm-hmm. You filed the motion.
And the note, order to show cause, and the note for motion.
And clearly the order to show cause wasn't signed, I think is what we're getting to.
Yes, I guess I understand. Okay, so then now I need a little more clarification, if you may. If the judge is going to recuse himself, and that's the drag, is he also going to change the venue?
No, all you did was provide a declaration. Hang on, I'm going back here. The declaration and affidavit of Darcy Adams. Hang on, it takes a second because I'm working from home.
I appreciate it, thank you.
Mm-hmm. Okay, that was filed on December 11, your declaration and affidavit in support, and your motion. Was it noted up?
Yeah, it was.
Was there a hearing?
No, I was told by Bryson Greenfield that they were
Greenwood.
not... Huh?
Greenwood.
I'm sorry, Greenwood. I was told that he was not going to, that the judge was not going to sign the recusal.
Well, he won't sign a recusal order because he doesn't feel like he needs to recuse himself, but he won't hear your case because you asked him to. But as far as change of venue, that needs to be noted up for a hearing. That's not something that you can just ask for on the pleadings.
All right, and then I guess I was mistaken because of the RCWs.
Yeah, I don't know what you're talking about, but yeah, motions for change of venue happen in open court. It's not something that you can just ask for in your pleadings.
So then, can I ask?
Litigation can happen in just the pleadings, as it did.
Now, I'm not aware, like, originally they didn't accept the recusal because I didn't file an ex parte and pay $30.
The order for recusal?
Yeah. So I resubmitted it.
I'm sorry, what? I don't think that you're understanding. He is not going to sign an order that says he is not fit or capable or shouldn't hear your hearings because he doesn't know what you're talking about and saying that Jeff stayed with him. He's got no clue.
Right, and I have no clue either. That's just what Jeff told me.
And you said to him in your declarations that you don't want him to hear it because you don't think that he can be unbiased or impartial or do this fairly. You know, he's not going to hear it. So, no, he won't sign an order that says he's not fit. He just won't hear your matters. And when they come up, I'll arrange for a court commissioner or a visiting judge, whatever I can do.
Okay. Yes,
you just need to let me know ahead of time so that I can make sure there's someone to hear it, or it'll get stricken right off the calendar. And that's the same for everyone. I mean, attorneys, everybody. If I don't know, I don't know, and then it gets stricken because I didn't know and there's no one to hear it. Do you follow?
Yeah, I kind of do.
Okay.
You said that you didn't see it in the...
It's not in your file. Your order, he didn't sign it. It's not in the file.
But I did file it.
You sent it to be filed, but I'm imagining if they still have it in the clerk's office, they've now called it a proposed order because it's not a signed order. The judge wasn't going to sign it.
Okay, because I'm understanding that I can only ask for contempt in the court that made the order to begin with, which is a parenting plan.
That is correct, and I need to get my hands on it. I need to see it so that I can give it to a court commissioner to sign.
Okay.
You don't want Judge Huber signing anything or presiding over anything, so I need to get it to a court commissioner or a visiting judge. And I guess what I was trying to say earlier, and I'm sorry that I wasn't clear, I never saw it.
Okay. And then it just brings it to my attention. Okay, so I don't have a personal problem with Huber, but based on what my ex-husband told me back in March of 2012, I felt the need to recuse the judge. I was not trying to upset him.
Oh, he's not upset at all.
Okay, good.
He doesn't know what you're talking about, and he doesn't know Jeff. And so it's not a problem that he's not going to hear your matters. The only problem is that he can't sign any of your orders. He can't do anything now. Everything has to be arranged for a visiting judge or a court commissioner, and the court commissioners only come when they're scheduled to come, and that's when I know that they need to come for something. But like on that order to show cause, is that what you're saying that Bryson said he wasn't going to sign?
No, Bryson told me he wasn't going to change the venue. He wasn't going to sign the recusal.
Yeah, he didn't sign that order. And if you still want to change the venue, then you need to note it up for in court. Well, right now we can't do in court anything, but at least, a court hearing that we could do by phone or Zoom or something if you still want that to be heard.
Okay, and then that leads me to my next question. If the judge is going to recuse himself, then wouldn't the change of venue go hand in hand with that?
No, because I have court commissioners and visiting judges, and it's not the same criteria.
What is the criteria?
Well, I don't know without looking at the law, but you can say, I don't want you to hear anything because of whatever reason, and the judge says, okay, good enough. To change a venue, there's got to be an other reason, and I don't know.
Well, the other reason was
another reason.
The other reason was Hotchkiss, but he's no longer on the bench.
Right, but you filed your motion for change of venue, and Judge Huber was on the bench, so that isn't clear.
No, I know that, but I did file an affidavit on June 15th, 2015 that the judge ignored the day before he changed custody of my daughter.
So if you want your motion for change of venue to be heard, you're going to need to renote it, do a new note for hearing, and let me know that you're doing that when you're doing it for, so that I can see to it that I have a visiting judge or a court commissioner to hear it.
Is there a proper paperwork that I need to file?
Well, you've done it before. You've done your motions and your note for motions. Your note for
Hold
hearing.
on, though. I just got told that I wasn't properly procedural with this most current hearing.
Order to show. First of all, it wasn't served properly, but Collier went ahead and accepted service.
How is it not served properly?
I don't know. I wasn't in the hearing, and I read to you what the minutes said, and that's what Commissioner Safar found.
He found that it wasn't properly served?
Yes, and then Collier went ahead.
Wait. I think I understand. It wasn't properly served because it wasn't signed.
Correct.
Okay.
That's what I'm guessing as well, because I wasn't in the hearing.
Okay, no, I think that makes sense.
Okay. So now if you want it to be heard, so now you would go ahead and do another note for hearing. I don't think you need to file another motion because you included it in your motion to disqualify, but I do think you need to file another note for hearing and make sure that Justin Collier is served.
Okay. And the only reason I didn't serve him was because Bryson told me to go ahead and file ex parte. I didn't file ex parte, and then it was refused, so I filed ex parte because I was told to by Bryson Greenwood.
Well, I don't know. I mean, I don't know.
And then they never took that $30 from my account.
I wasn't there for what went down. I'm just saying, if you want to do it, let's do it now and do it correctly.
Okay.
And you're not going to do an order to show cause. You're just going to do a motion to change venue.
Okay.
Unless you want to do a motion in order to show cause for contempt, in which case you're going to do it all again and make sure that the order gets to me so that I can get it to a commissioner to sign if they find good cause for to show cause.
Okay. So, and as we stand, my daughter has not seen a pediatrician since final trial 2016.
There isn't. I know that you know there isn't anything I can do about that.
No, I know. I'm just making you aware of it. And then also the
Working
fact
from home,
that
and these are
I haven't seen
that I
her
would put in
since
the-
July 8th
no, anyway.
of 2018.
I'm sorry, what?
I said, and also I have not seen her since July 8th of 2018.
Okay, well, like I said, these are not notes that I'm taking. I'm working from home, and even if I were, they wouldn't go in the court file.
That's fine. I'm just letting you know because if you're saying I need to contact you,
you need to contact me so that I can get a commissioner to sign the order. That's all.
Okay. And then, I don't know. And then my other question is, do you have access to January 29th minutes of 2019?
Probably. Why?
Because that's kind of why I'm back in court.
Okay, but
I was just wondering if you have them, if I can just hear them one more time while I have you on the phone.
yeah, here, let me get that up, and then I will read them to you. January 29, you said?
Yeah, 2019.
Oh, more than a year ago. Oh, no. Hang on just a second. I've gone too far. Sorry, this is a very, very touchy program, and all it takes is nothing, and it just freaks out.
I know.
Okay, motion hearing, January 29. Okay, it was Judge Hotchkiss. Oh, minute, stop it. Attorney Gunn addressed motion to reinstate visitation with proposed supervisors. Attorney Collier responded with strong objection. Attorney Gunn rebutted. Then it looks like maybe there was a break. The court addressed the parties. The court requires that counselor be informed of reason for counseling, and court receives status reports. Court requested a resume from Ms. Sizemore and declaration that Ms. Sizemore will abide by reporting. No changes until then. Attorney Collier requested to receive counseling records. Court agreed. And that's it.
Okay. I think I'm exhausted on questions, but I do have clarification, and I appreciate your time today.
You bet.
Okay, thank you.
Bye-bye.
Bye.
You have reached the Douglas County Clerk or call.
.net.
Clerk's office, this is Casey.
Hi, Casey. I was hoping maybe Bryson would be available since I'd spoken to him yesterday.
Yeah, hold on just a second.
Thank you.
By visiting our website?
To double check that everything went through yesterday.
Yeah. Yep, all your e-filing came through and we put it in the judge's box.
Okay, no, while I have you, I don't want to keep calling you, so I was just wondering because I hadn't gotten any confirmation email or no funds had come out of my account.
Oh, okay. Yeah, it was processed by e-filing yesterday, so everything's good. It did look like maybe you wanted to change a venue to Chelan County.
Yes, please.
Okay. So if the judge does find that and does grant your change of venue, then we'll transfer the file to Chelan County, but it's going to be a filing fee to file it in Chelan County.
Right, and I understood the RCW to take care of that under 4.12.090.
Oh, what is that?
Basically, when the original case in general should never have been in Douglas County, and the person that filed that knew that.
Oh, I see. Okay. Interesting.
Yeah.
So yeah, let's see. I'll just take down your number, and if it's signed, I mean, you're gonna have to pay the filing fee to file it in Chelan.
Sure. However, I mean, it's just the way it reads.
Was it a parenting plan case?
It originally was a divorce that turned into a parenting plan, but the problem was nobody lived at the time of the divorce petition. Nobody was born. Everybody's from Chelan County. Even the crime, if there had been one, was committed here, not in Douglas County.
Okay. Okay, I will. So your phone number is 670-1679?
Yes.
Okay. So yeah, as soon as we get it back and everything's fine, I'll give you a call and I'll let you know.
Sure.
You'll just send us some money and then I'll transfer the file to Chelan County.
All right, sounds good. Thank you. I appreciate it.
Yeah, you're welcome.
I'd rather get a call back from you than have to bother you, but then that's just one more thing for you to do. So I just, I don't want to be a bother.
No, that's fine.
Okay.
Here, so I will call you back as soon as it's fine.
Thank you.
You're welcome.
Bye.
Bye.
Hello?
Hi, this is Bryson in the Douglas County Clerk's office in Ottawa with Darcy.
Yes.
Okay, so the judge isn't going to change the venue and he's not going to recuse himself from the case.
I figured as much. All right.
Okay.
On to plan B. Thank you.
You're welcome.